Good morning, Washington State. This is Amanda Pauley. We have quite a large turnout today, so we're going to go ahead and give everybody just a couple more minutes to log back in, and then Marley and I will get started. So hang out there and we'll be right with you. Okay, Washington, can do me a favor and let me know that you can hear me by everybody throwing a hand up. Oh, I love it. That was wonderful. All those little green hands going straight up. Fantastic. Really nice to see those hands. We'll have opportunities to ask questions later and throughout the broadcast today. Thank you all so much for joining us. We're really happy that you're here. We're going to go ahead and get started. So right now, what I would like to do is introduce you to Miss Marley Hawkendonner from the Northwest Fair Housing Alliance. She has a lot of fantastic information for us today, specifically regarding the fair housing rights when it comes to participants who may or may not have criminal records. So I'm going to go ahead and without further ado, pass it off to you, Miss Marley, and I will be here fielding questions and helping out where I can.
Wonderful. Good morning. So I hope that folks can hear me. I'm going to do the same. Can a few folks raise their hands and indicate if I'm coming through loud and clear?
Looks that way.
Let's see here. Okay, good. Yeah, a lot of folks coming in. Okay, great. Okay, well, thank you for joining us today. I am thankful also to Amanda for giving me this opportunity to come back and talk with you folks about fair housing issues again. I appreciate being able to spread the word as much as I can about fair housing, and there are a lot of different aspects to it. Today, we're going to focus on the use of criminal records by housing providers and how that can be a barrier to some protected classes under the Fair Housing Act, and what a model policy should really look like, what housing providers should be doing. So that's the goal today, to provide a little bit of understanding about the Fair Housing Act and its application to criminal record screening in housing. So I am the director of Northwest Fair Housing Alliance. We're a nonprofit based in Spokane, Washington, although we serve 17 counties in eastern and central Washington, and then a lot of our education and outreach initiatives go even beyond the state of Washington. We are based in Spokane, however, and like many of you are probably on, if you're in the state of Washington, you are probably working from home unless you're an essential service, providing an essential service, which many of you perhaps are. I know that I myself have partaken of many webinars already beginning last week. It's a great opportunity to get more education while you're shut in at home and not able to do some of your other usual things. So thanks for joining us today. I'm thrilled to see such a large group. It looks like we have about 205 folks already on and a few more trickling in as we go. Why don't we go ahead and do a poll quickly and see, it looks like it's in progress. Great. Let's see where you folks are from. The options are Eastern Washington, Western Washington, Central, and I'm not sure anymore given the current circumstances. So, oh, looks like Western is beating everybody else out so far, 75%. We'll give you just another minute or two. And if you're from somewhere else outside of Washington, why don't you go ahead and type in the chat and share where you're from. Okay, Eastern Washington is catching up a tiny bit, 20%, and 71% for Western Washington. Well, thanks all again for joining us today. So today I am going to be discussing the April 2016 HUD guidance on use of criminal records by housing providers. This came out in 2016 under the prior federal administration, but is still currently in effect and is the only real known guidance that we have from HUD in terms of the application of the Fair Housing Act to criminal history. As I believe Amanda may have indicated, we have the handouts. There are 2 handouts that are available for you for download on this webinar. If you look in the dialog box there, the actual guidance itself, which is about 16 or 17 pages from HUD. And I'm going to be trying to summarize that and distill that a little bit for you today. And then there's additionally a short article about the guidance that I put together last year. And so that's available for your download as well. As we go along, if you have questions, go ahead and type them in the chat. Amanda's going to be monitoring for those, and at her discretion, she'll either interrupt me if I'm not seeing the questions or hold them till the end, and hopefully we'll have some time there to have a little bit more discussion. So the computer has just a slight delay there for me. Okay. So the 2016 guidance addresses how the Fair Housing Act applies to criminal history screening in housing transactions. And so you might wonder, what does criminal screening have to do with the Fair Housing Act? Because the Fair Housing Act, as many know, protects different groups that our legislature has chosen to protect from discrimination, and these are referred to as protected classes. And there are 7 federal protected classes, including race, color, religion, sex, disability, familial status, that means having children in the household under 18 or about to come into the household, and national origin. So when you look at that list, you don't see anything there about criminal history being a protected class. Some jurisdictions, such as the city of Seattle, have enacted ordinances which do have essentially a ban the box type policy for housing. Some have done it as far as employment, but not housing. But there is nothing in the federal law or the Washington state law against discrimination that includes specifically criminal history as a protected class. So we're going to meander through the HUD guidance to try and show you how that can become a fair housing issue, even though it's not a specific protected class. There are 2 methods of proving that a criminal history policy violates the Fair Housing Act. So we're going to be looking at two theories: discriminatory effects, or sometimes called discriminatory treatment, or intentional discrimination, where you do something on purpose in your screening to discriminate. And the second is disparate treatment, or disparate impact or disparate effect, where you do something perhaps even unintentionally with a policy that you think is neutral, that the housing provider thinks is neutral, and but its application goes into effect, and the burden of that policy falls heavier on one of these protected classes than others. And so that's how criminal history screening gets pulled into fair housing. So the guidance focuses on race and national origin as protected classes that are impacted by criminal history screening policies. However, keep in mind, the guidance doesn't rule out and acknowledges that other protected classes may also be affected. So as we go along, you might think about, are there people that you work with, clients, patients, those that you interact with in the public that are in other protected classes, perhaps disability, that are overly represented in the criminal justice system that might be impacted by criminal history screening policies? Because the legal arguments, the steps that we're going to go through from the guidance today, would be equally applicable if you were making that argument. Okay, so the HUD guidance starts out with some background information about incarcerated and criminally justice impacted folks in our society. The background section notes that formerly incarcerated individuals, people who have been convicted but not incarcerated, and people who have been arrested but not convicted encounter significant barriers when they try and secure housing after their release, or even if they have not been incarcerated, once they have a criminal related blemish on their record, they have difficulty securing housing because of that criminal history. And the guidance provides information on statistics, provides statistics for the nation with respect to how large a population that is criminally justice affected. As many as 100 million US adults, nearly 1/3 of our population, have a criminal record. The US population of 2.2 million adults is the largest in the world. The US prison population, not our total population, our prison population of 2.2 million adults is the largest in the world. As of 2012, the United States accounted for about 5% of the world population, but we had 1/4 of the world's prisoners in our American prisons. There are a lot of citations if you're interested in that, those type of statistics in the HUD guidance. So since 2004, an average of 650,000 individuals are released annually from federal and state prisons, and over 95% of current inmates will be released at some point. So most folks who have been in the prison system are getting out or are out and will need housing. When individuals are released from prisons and jails, their ability to access safe, secure, and affordable housing is critical to successful reentry in society. And the increasing numbers of people leaving institutions face an increased risk for homelessness if they can't find housing. And conversely, people who experience homeless are vulnerable to incarceration. So sometimes it becomes a revolving door. So continuing with the background information of the HUD guidance, it's noted that across the United States, African Americans and Hispanics are arrested, convicted, and incarcerated at rates disproportionate to their share in the general population. They're overrepresented in our criminally justice impacted population. Criminal records-based barriers to housing are therefore likely to have a disproportionate impact, a bigger impact on these home seekers. Having a criminal record, as I mentioned, is not a protected class under the Fair Housing Act, but a criminal history-based restriction that could violate the Fair Housing Act if, without justification, its burden falls heavier on renters or housing market participants of one race or national origin over another. Again, this is known as disparate impact. So if a policy has a disparate impact and does not have adequate justification, which we're going to delve a little bit more into, it can violate the Fair Housing Act. So disparate impact or discriminatory effects liability can involve a facially neutral policy, a policy that's not intended to discriminate. It's intended to be applied across the board to everybody, but when it goes into effect, when it's implemented, has a bigger impact on a protected class. There is no intent to discriminate required for this, for disparate impact or discriminatory effects liability to be proven. So even if somebody is not trying to discriminate, if their policy has a disparate impact on a protected class, it can violate the Fair Housing Act. So the courts utilize a three-step burden shifting standard to analyze disparate impact. Some of you may have heard in the news that HUD was proposing a new rule regarding disparate impact. That a new rule has not been implemented, but there is a proposal which would readjust some of the burdens and the analysis for disparate impact. But currently that has not gone into effect. HUD solicited some comments on a proposed rule. But for quite some time, courts have been applying a three-step burden shifting standard, and the HUD guidance as well, which has not been rescinded, uses that same three-step burden shifting standard to analyze whether a policy violates the Fair Housing Act, has a disparate impact on a protected class. So there are three steps here. So to determine if a policy violates the Fair Housing Act. So number one, the HUD guidance outlines these three steps. Number one is to evaluate whether the criminal history policy or practice has a discriminatory effect on a protected class. If it doesn't, then you're done. But if the policy has a discriminatory effect on a protected class, then step two, the burden shifts to the housing provider to proffer that the policy is necessary to achieve a substantial, legitimate, non-discriminatory interest. So the housing provider then would need to come back and say, well, it may have a disparate impact on protected classes, but it's necessary. I need to have this policy to achieve a substantial, legitimate, non-discriminatory interest. And then again, the burden shifts back to a complainant to say that there's a less discriminatory way to go about achieving your interests. You don't have to have the policy that you're using. So for
Hey,
step
Marley,
one,
this is Amanda.
yes, sure.
Is there any way that I can ask for our audience is talking about having some difficulties with audio, and I'm doing just fine with audio.
Okay.
However, can everybody, if you're having a problem with audio, only if you're having a problem, or if you're not having a problem, raise your hand.
Okay, so the not problems are raising their hand.
Okay, so then, yeah, so if we see somebody in there who's not having or who is having a problem, their hand won't be raised because they won't have heard us. So,
Yeah.
Okay, so it looks like it's just one or two people possibly.
Yeah,
maybe.
It's hard to tell always which end it's on. We've been having some staff meetings remotely now under this new system of working from home. And it's funny, some of us at times will be hearing and seeing each other wonderfully, and then other times some people aren't. So it's always hard to know whose internet connection it is or which equipment it is.
Right. I try to suggest phone for audio and then computer for visual.
Right. Muting yourself can help too. I think everybody should automatically be muted, but if you're not muted, sometimes you can get an echoing or reverberation if you're not muted.
That's true too.
Yeah. Well, shall I continue here?
Yes, please continue.
Okay. Yeah, I apologize
for anybody who's not able to hear this, we can always we'll be sending out the link later for the recording. So please just hang tight. And just make sure that your internet connection is good, and make sure that you're in a good place with your phone.
And I'm also happy to provide the PowerPoint as well if people want to have that to reference to, or if they were unable to hear or attend.
We add that in, so that's perfect.
Right.
That'll go in the email later. So that's absolutely wonderful. Thank you, Marley.
Perfect. Okay, great. All right. Well, I will continue, and hopefully the greater majority can hear. So, but yeah, do let me know if you start seeing many more people indicating they can't hear. So, okay. All right. Well, so we're at step one. How do you prove step one that a criminal history policy or screening policy has a disparate impact on a protected class? How do you know if it's going to violate the Fair Housing Act? Okay, so this is the first step. Again, once I get started, it takes a second to catch up with the slides. Okay, here we go. So the HUD guidance says that people can use national statistics such as some of the ones that I cited at the beginning of the webinar, to show that a criminal screening policy can have a disparate impact on protected classes, particularly people of certain races or national origins. But again, you may be able to make this case as well for people with disabilities if they are overly represented in the criminal justice system. So national statistics can be used, and HUD will accept those for with complaints alleging that a policy violates a Fair Housing Act. Preferably, however, you also supplement with local data to show that in your specific community, your city, your state, your region, that there are also statistics that show that people of color are disproportionately impacted in the criminal justice system. And I can say that that does hold true for the city of Spokane. We did some work with the city on their analysis of impediments recently, and there's some data from the Burns Institute that looked at, I believe it was 2016 data that did show disparities based on race in Spokane. We also did some work with Snohomish County and City of Everett on their analysis of impediments, and the same thing true in Snohomish County and the criminal justice system there, and the state of Washington. Really across the board, unless you're in a really unique circumstance, there are, for many reasons and factors, people are overrepresented in criminal justice system, people of color. So you ideally supplement your complaint if you're helping somebody put together a fair housing complaint because they can't get into housing because of a criminal history screening policy. You supplement with local data. So national data is acceptable, local data is preferable, but you can ideally use both. So then step 2, the housing provider gets to assert that their policy is actually necessary to achieve a substantial legitimate interest. So what is that? What's a substantial legitimate interest for having a screening policy that a housing provider can have? The housing provider needs to prove that the practice is justified. It's necessary for achieving this substantial, legitimate, non-discriminatory interest. It can't be a hypothetical or speculative interest. So it can't be something that they're fearful about, but they don't have any verifiable information to base that fear on, or the speculation. They can't make generalizations or speculations about certain populations being more dangerous, or people even with criminal histories being more dangerous. They have to be relying upon something concrete. And so this is the burden of the housing provider to prove that they have a real interest, not just something hypothetical. The guidance from HUD does acknowledge that ensuring resident safety and protecting property are usually considered to be fundamental responsibilities of a housing provider. So these are probably good reasons for having certain policies. Ensuring resident safety, protecting property. But these need to be the actual reasons for the policy, not just again, fear or speculation, or a proxy made up reason in order to keep people out with criminal histories. And the housing provider needs to prove that its policy or practice for criminal history screening actually assists in protecting resident safety or property, so that it actually does what they are contemplating it will do. Bald assertions based on generalizations or stereotypes are not sufficient to satisfy the burden for step 2, according to HUD. And then HUD delves further into their different types of screening policies. And so if there is an exclusion, for example, based on prior arrests, not convictions, but arrests, HUD says that an arrest alone does not prove that a crime was committed, and that a prior arrest without a conviction is not going to satisfy the burden of step 2 of showing that the screening policy is necessary to achieve safety of people and property on the premises. So one definite takeaway is that a screening policy should not exclude people based on arrests alone. If you see that in your work with people, that's definitely a red flag, and probably would violate the Fair Housing Act. Again, given the specific demographics and statistics for the area that you're working in. But again, almost across the board, when you start delving into criminal justice statistics, you can find those disparities based on race and national origin. So takeaway, a policy should not exclude people who have been arrested but not convicted. As far as convictions, HUD says that a conviction is usually pretty reliable evidence that somebody did commit a crime. However, not all crimes are equal, and some again pertain to pertain to people's safety and protection of property, and others don't. Some have nothing to do with whether or not somebody is going to be a good tenant, a good housing community member. So having a blanket prohibition on any kind of criminal conviction is not going to meet the burden of step 2 either. That's not going to be a good enough justification for a policy, an overly restrictive policy. So again, another takeaway from this HUD guidance is that a policy that says no felony convictions or no criminal convictions, no misdemeanors, those kinds of blanket policies, even though they're addressing convictions, are too broad. The housing provider instead needs to show that their policy distinguishes between the types of criminal conduct that relate to the risk of resident safety and protection of property and the kinds that don't. So again, broad policy, blanket policies violate the Fair Housing Act. So keep that in mind again as you're, yes,
We have some questions if you'd be willing to answer some real quick.
Sure, go ahead, yeah.
Awesome. So we have one person here that says, who's asking, can we advocate and change state policy to include more under protective classes at the state level? That's the first question. So I'll go ahead and give you a chance to answer that.
Mm-hmm. Yes, absolutely. Certainly, you can advocate for that. There are some groups, I think, that are looking at that type of thing. The Washington Department of Commerce recently completed its analysis of impediments to fair housing, which is an annual report that jurisdictions receiving certain federal funds for housing have to complete. And they note the high incidence of criminal history screening as a barrier. And I think they are proposing that that's some policy that be looked at. But most definitely, if you're seeing this as a problem in your community or in our state of Washington, it can definitely be something to talk to your elected officials about. It also, by having policies that protect or provide more guidance for housing providers, it adds clarity, because as we're going through this long memo from HUD and all these different legal arguments, it's sometimes as clear as mud. And so having something that's more specific that we could point to and say, here is our law, it definitely protects or allows these types of things with regard to criminal history screening. So definitely, I think there are opportunities if somebody is interested in lobbying or policy change. There's some different groups, I think, that are looking at this as well, some nonprofits in Washington.
Wonderful.
And yeah, another one?
The next question is, can you please give an example that you've faced that, I don't know that I know this word, that it says, I don't know if that's peculative reason was used, which sounded reasonable, but actually it was not.
Okay, reasonable. Okay, I was just trying to understand the question as well too. Okay, so an example where somebody, okay, sure, that gave a reason that's not. I think again, we do see, and I'm going to delve into some
particular. It was particular.
Sure. Okay. Okay. Yeah.
All right. Good. I was like, gosh, I have a pretty good lexicon, but I don't think that one's in it.
Oh, that's okay. Yep. As we're typing along here. Okay. So an example of where we've seen a reason articulated that really wasn't sufficient. Again, it's going to be these types of assertions that we need to protect the community, so we have to have this. And often it's not really thought out much more than that. It's customary to have these types of policies. We've seen them all over the country for years, and so many housing providers just adopt them without, I think, really even thinking about, is it necessary and what type of exact policy they should have. So in terms of, reasons, yeah, they're going to say health and safety of people and property, but it needs to be more thought out than that, and usually it's not. Um,
That makes
so I'm
sense.
not sure. Yeah, but I'm gonna get
Well,
through some different cases that have actually occurred around the country, just to kind of give you some ideas of how this has played out, and what kinds of things have been found to violate the Fair Housing Act. So that may be helpful too in trying to bring this to life a little bit.
there's lots of questions.
Oh, okay, okay. Well, then why don't I just
So
continue
why don't
trucking
we just go?
along?
Yes,
Yeah,
that
and
sounds
then
like a
at
good
the
idea.
end
And
we'll try and grab some. Yeah.
right. And folks, if some of these questions don't get answered right away, I will I will offer Marley the questions through a Word document, and maybe beg her really politely if she could write up some brief responses to each of them, and then I will forward them through so that everybody has the answers to them as well, written out.
And
And
I'm
we'll do our
happy to
best
do that.
to thank you, Marley. We'll do
Yeah.
our best to, I think you did that for me last year too,
I did.
because there were
I was
lots
just gonna
and
say.
lots of questions.
Yeah.
And we'll send that through with a follow-up thank you email too. So if your questions don't get immediately answered this time around, then we'll do our best to accommodate for the follow-up questions to be answered in email.
Great. So yeah, I'll definitely do that. So if we don't get to the questions today, and I know there's so many different scenarios that people have either encountered or can think about. So if at the end, if the information that we continue to discuss doesn't answer it, yeah, I'm happy to try and take some questions and that can be sent out afterwards. So. Okay, so then we're on to step 3. So presumably you only get to this, well, you only get to this step if the housing provider has come up with a reason that they say they need their criminal history screening policy. They say it's necessary. I'm not trying to discriminate. I need it for health and safety. This is why I need it. I didn't make this up. So presumably, if the court allows the case to continue, or HUD at this point, then you're at step 3, where it shifts back to the tenant or advocate working with the tenant to say that, well, your interests that you're trying to protect may be legitimate and necessary, but there's an alternative way that you could be addressing that interest, protecting that interest of safety and protection, than having these broad blanket policies that either reject people because of arrests or any conviction ever. There's less discriminatory alternatives. And so HUD's guidance memo articulates a less alternative method, or a less discriminatory method. And so I think housing providers are wise to try and adopt this kind of a method. And in fact, I'll conclude after we look at some cases that have addressed criminal history screening around the country, I'll conclude with a model policy that was the result of a settlement that the housing provider agreed to implement, that does try and implement this individualized assessment, because a lot of housing providers are wondering at this point, well, what can we do? How do we do it? So an individualized assessment takes a look at mitigating circumstances. So rather than having a blanket policy that just says no criminal history whatsoever, we're going to allow you an opportunity to give us some information about what happened. How old were you at the time? What rehabilitation efforts have been undertaken? How long ago was it? What was it? What was the nature of the conviction? Was it something that doesn't even have to do with housing? Was it maybe a case of mistaken identity? There have been cases like that as well, where there's something on your record and you have a very common name and it wasn't you at all, but it comes up on your screening background report. So giving people an opportunity to provide some mitigating information. And additionally, allowing or going forward with the screening of other factors like credit score, perhaps, rental history, income requirements, if housing providers have those, using those first and then going through the criminal history screening. Because if somebody doesn't pass those other things, then there's no point really in getting to the criminal history screening portion and going through an individualized assessment if they're not going to perhaps be able to afford the apartment or have some adverse eviction history that's going to preclude them from being able to rent there anyway. So the Washington Attorney General's office did undertake a couple of years ago some investigation in Washington regarding the use of criminal history screening policies in housing. And they utilized their civil rights unit. They had an investigator who posed as a tester as a renter with an unspecified felony conviction was one profile, or a 10-year-old felony theft conviction. And they contacted 50 rental companies around the state of Washington. Of those, many landlords appropriately followed up with questions about the nature, circumstances, and timing of the felony. However, 5 housing providers denied the applicants based on criminal history without asking for further information, and 1 replied that criminal background would result in an automatic denial. So as a result of that audit, the Washington Attorney General's office sanctioned the 5 companies for refusing to rent to somebody with any criminal history, and they entered into consent decrees with these defendants. All the decrees included monetary fines, civil penalties, required the adoption of non-discrimination policies, and training for their employees. So that was an investigation that the state undertook. I've talked a lot about the analysis for the disparate impact theory of discrimination, the 3 steps. However, criminal history policies can also be used in terms of intentional discrimination, treating people differently. So a housing provider may have a policy for screening history, and if they make exceptions to white applicants but not people of color, then they're treating people differently. So that can come up. There was a case in Tennessee that was filed in U.S. District Court in 2018, United States versus Dyersburg Apartments, again in Tennessee. And this involved an individual complainant who alleged race discrimination. He applied to rent. He was an African American gentleman, and he had a criminal record that involved a 2008 conviction for writing a bad check with 2 counts of forgery, and he was sentenced to 36 months. And he applied to rent but was denied because of a felony conviction. However, there were 2 white individuals who were allowed to rent there, one of them who had a conviction for sexual battery and another who had a conviction for selling counterfeit controlled substances. So those 2 individuals were allowed to rent, whereas the African American gentleman with the forgery charge was not. And so he filed a complaint alleging different treatment rather than disparate impact, intentional discrimination. So there have been several cases. I'm going to talk about a couple more as we go on, delve more into the disparate impact, but usually often both claims are made, disparate impact and disparate treatment. The Greater New Orleans Fair Housing Center came out with a report, also pretty enlightening, about some of their paired audit testing. They conducted 50 tests in New Orleans. And of those 50 paired tests, where they used a white tester and an African American tester to inquire about housing opportunities, 50% of the African American testers with a criminal background profile experienced different treatment. So intentional discrimination, different treatment compared to their white paired counterpart. So in 25 occasions of the 50 tests, there was different treatment of the black tester, and often there were multiple instances of discrimination. So not just one time, but there were many things, and that could include quoting more lenient policies to the white testers rather than the African American testers, providing different customer service, encouraging or discouraging the rental transaction based on the race, making exceptions to the rental policies for the white tester and not the black tester. And even when there were discretionary policies that allowed the housing provider to make some case-by-case decisions that consistently favored the white tenants. So when policies were discretionary, case-by-case, or unclear, African Americans received unfavorable different treatment 55% of the time. So that was an enlightening study about intentional discrimination as opposed to disparate impact, so where you're treating people differently. Now, I want to take the guidance, the HUD's guidance, and look at how some of these cases have been brought around the country, the kinds of arguments that have been made, the kinds of things that have been alleged to violate the Fair Housing Act, and the sort of resolutions that have come out as a result of these cases. The first is the Fortune Society case. This case was actually filed before the HUD guidance came out in 2016, and it's cited to in the HUD guidance. So HUD was quite aware of this case when it issued its 2016 guidance. And the Fortune Society actually uses the same three-step analysis for disparate impact for criminal history screening. And HUD cites to that case in its guidance. After the guidance came out, there were a couple of cases filed right away. The Sams case in Georgia and the Equal Rights Center case was filed in DC, District of Columbia. And these were three of the earliest cases, although they have continued since. And so just to give you an idea of some of the things that have been alleged, and then ultimately all of these three have settled. The Fortune Society case just settled this past October. It went on, it was filed first and it lasted the longest, but it did just recently settle for about $1.87 million. So the Fortune Society case involved a nonprofit organization in New York City that's dedicated to reentry and reintegration of formerly incarcerated individuals in New York City. They serve about 5,000 clients a year, and of those, about 95% are African American or Latino. In 2013 and 14, Fortune tried to rent apartments for its clients at a complex called the Sandcastle, which was a 917 unit multi-building apartment complex in Queens, New York. And when the defendants, the owners and managers of that property, learned that formerly incarcerated individuals would be living in the apartments, they refused to rent to them because they had a policy of automatically excluding any person with a record of criminal conviction. So it was a blanket policy. And Fortune, the nonprofit, alleged that this ban was discriminatory and had a disparate impact on the basis of race and color. They filed a complaint in district court in 2014 using the same similar three-step analysis that the HUD guidance goes through. And to show that the ban had a disparate impact based on race, Fortune relied on area statistics. And so they cited to things like, in New York State, more than 50% of inmates released in 2009 were African American and over 25% Latino. However, New York's general population only has about 16% African American and 17.6% Latino. So these groups were much more represented in the incarcerated population than the general population. They cited to the fact that African American men who live in New York City and satisfied defendants' other residency requirements, like 3 times the rent, were still likely to be excluded compared to whites under this policy. So even when they tried to factor by income requirement, there was still a disparity that African American men were 3 times as likely as whites to be excluded by this criminal screening policy, and Latino men 4.5 times. So those were the kinds of statistics that they used. The Department of Justice, again under the same administration, early on in 2016, October, filed a statement of interest in this case where they said that they concurred essentially with the 3-step process. So again, that was another indication from HUD that this was still the process to follow in analyzing disparate impact in criminal history. In July 2019, the court denied the defendant's motion for summary judgment and allowed the case to proceed. And as I mentioned, it finally settled in October 2019 for $1.187 million. The Sams case was filed in Georgia in 2017. This one alleged both intentional discrimination and disparate impact discrimination based on criminal screening policies. This involved the Westgate Apartments in Garden City, Georgia. It was a Section 8 based affordable housing project with 94 units in 10 buildings. The tenant population, with the exception, I believe, of one household member, was entirely African American. So, 99.9% African American. In 2013, new managers came on, and they adopted a new tenant selection plan that imposed a 99-year rule. It barred tenancy if a person had a record of conviction, whether it be a misdemeanor or a felony, within the past 99 years. And then it started evicting in-place tenants based on this 99-year rule, even though there were several in-place tenants who had previously disclosed their criminal history and had been allowed to live there. This case was interesting as well because it involved coordination between the local police department and the property management company. It was really seemed to be these mass evictions were being done at the behest of the law enforcement, providing information to the property managers as to who had criminal histories and encouraging them to terminate their tenancies. So the city was sued as well for the police involvement in these policies. So on one hand, it was argued that this was intentional discrimination because this property owner had other properties that had equally high levels of crime or people with criminal histories, but they were not singled out for these mass evictions because they were not African American, whereas this particular property was. And so that was alleged intentional. And then the 99-year ban was alleged to have a disparate impact. Even if you were applying this to everybody, a 99-year policy on any kind of criminal history is going to have a bigger impact on, in this community, on people of color who are more likely to have a criminal record. So that's what they argued there. And again, they relied on local and state and federal statistics to show the disparities in criminal justice impactment. In 2017, the case settled for $112,000 for plaintiffs. The third case up on the screen, the Equal Rights Center versus Mid-America, this involved 55 apartment communities across the nation with about 20,000 units. So this was really a mega landlord owned and operated these properties. And the subject property of the lawsuit was in Washington, D.C. It was the Post Massachusetts Avenue property in Washington, D.C. And this one came about as a result of a fair housing agency conducting testing. I believe that they started out looking for something else. They were looking at the websites, the screening policies, and I think that they were doing some testing for a different protected class, if I recall correctly. But they started stumbling upon these barriers based on criminal history on the website in particular. The website basically barred anybody with a felony conviction from even applying. You couldn't submit an application online if you checked the box that you had a felony conviction. So there was no consideration of any kind of mitigating circumstances. It was an automatic bar. And it also advised that certain misdemeanors, unspecified, would be a bar as well. And the Fair Housing Agency conducted a series of tests on this property and confirmed that this was their policy. And so the Fair Housing Center the Equal Rights Center filed a suit against this property, again, this mega landlord that had this policy throughout many, many properties. And they proffered, again, they had to put forward a lot of statistics showing disparities. And they really broke it down into a lot of data based on the individual cities involved: Tampa, Florida, DeKalb County, Georgia, Collin County, Texas, all these places, citing to statistics that showed that people of color, African Americans, and Latinos were between 2 and 12 times times likely as whites to be excluded by these blanket prohibitions for any kind of criminal history screening. So really, these cases that have gone forward have relied on the expertise of statisticians and people that are able to really delve into the statistics and look also at, even if you control for things like, can the applicant meet a 3 times the rent income requirement? Can they have a certain income threshold? Are there still disparities based on race? This case also settled for $180,000, and the company had to change its policies, which obviously had a big impact given the large footprint of the 55 properties and 20,000 units. More recently, so those were 3 of the early cases that were filed. More recently, in October 2019, there was a case that was filed in Virginia that is still pending, I believe. And this one involved a property in Virginia with, there was a household comprised of a biracial female who identified as Black, and she had a criminal history record. She had an adult daughter living with her, and then there was an adult man, her partner, Mr. Phillips, and together I believe they had a minor child. So there were a total of 4 in this household. Only the man, Mr. Phillips, and the adult daughter were on the original lease in 2012, but the other plaintiff, the biracial female, moved in with the minor daughter in 2014. And so the 4 of them continued on in this apartment until 2017. They then requested a transfer to a larger unit from the same housing provider. At that point, a background check was run, and it showed that the woman had a felony conviction from 2008 for possession of cocaine, misdemeanor traffic violations, and 2008 arrests without convictions. And then it also showed that Mr. Phillips had a 2006 misdemeanor traffic violation, which they allege is actually a case of mistaken identity, was not him at all. Based on this criminal history screening that turned up this background, their application to transfer units was denied, and they were given a no-cause termination notice to vacate. So that case is still pending, but this shows how an individualized assessment might have vetted the accuracy of both the criminal records, particularly in the case of Mr. Phillips and his misdemeanor traffic violations, mistaken identity, and also assess the current risk for the housing community. Roughly 10 years later, was this woman's past drug conviction a risk to what she was doing now? She was currently enrolled in college, and presumably had been living peaceably in one of their units already since 2014. So that case is going on. So these cases are still being brought. Again, the importance of having an individualized assessment, giving the applicant an opportunity to provide countering information, can help both the tenant get in and clarify if there are inaccuracies regarding their criminal history, or to mitigate, show that there really is no risk, that the risk is significantly diminished or not there. And it can also help the housing provider. And so just to give a couple examples of what that process can look like, the Jackson case was in 2019 in, let's see, this was also a New York case. And in this one involved an African American with a felony conviction who met the income and eligibility requirements. He had no evictions, had acceptable credit history, and he applied and was rejected for a unit due to a felony. And he called twice asking to request an appeal, and his calls were never returned. So then he ended up suing the company, alleging disparate impact based on race. They proffered statistics showing that blanket bans on criminal history result in the denial of housing opportunity at a disproportionate rate for African Americans and minorities. And The housing provider asked the court to dismiss the case, and the court refused, stating that the statistical racial disparity that the plaintiff cited was directly related to the property's alleged policy of excluding persons with a felony conviction. So that one was still pending, but had they taken his calls, had they given him an opportunity to discuss his situation, there might not be a pending lawsuit there. Hall versus Philadelphia is a housing authority case filed in April 2019. This one actually benefited the housing provider when they allowed for some mitigation. So in this instance, there was a person who was denied a rental by the housing authority. They filed suit based on race discrimination. And he was denied allegedly due to his criminal record. As the case played out, apparently he was denied for two reasons. There was a police record of a felony guilty plea to involuntary manslaughter in 1997. So felony guilty plea, involuntary manslaughter in 1997. And then there was an unsatisfied landlord-tenant judgment for $871 still pending. So going through the housing authority due process procedures, he got a hearing. And at the hearing, he was able to provide information that clarified that the conviction was actually a misdemeanor, not a felony. And he was also able to explain some information about the landlord-tenant dispute. So the housing authority reversed their decision on the criminal conviction, and they gave him 30 days to provide proof that he had entered into a repayment plan with the landlord. He didn't meet the 30-day deadline, so they denied his application. A week later, he did send in the repayment agreement, and they granted his application. So they gave him several chances along the way, as well as an opportunity to clarify some stuff about his criminal history from 1997. He got into a unit, but then thereafter still filed based on race discrimination, and the court dismissed the case in favor of the housing provider. So again, giving somebody an opportunity to provide mitigating information can save everybody a lot of problems too in the long run. There's also a case, recent case from March 2019, just a year ago now, that makes it clear that consumer reporting agencies must comply with the Fair Housing Act when conducting tenant screening services for landlords. That was a little bit uncertain, but that case did involve a screening company. And so housing providers that rely upon screening companies to make decisions for them need to be aware, as do the screening companies, that if they make decisions based on criminal history screening and disparate impact case allegations are proven, they can violate the Fair Housing Act. This particular case involved a woman in 2016 who wanted to have her son, who was currently living in a nursing home, move into her apartment. He was recovering from an accident that left him unable to walk, talk, or care for himself. And her application to have him move in with her was rejected by her property manager, or excuse me, was rejected by the screening company. They said that she should not be allowed to have him live with her because he had a disqualifying criminal record. And they didn't give her an opportunity to explain any of the background. So as a result of the denial, the adult son had to stay in the nursing home for a year longer than necessary. The mother later was able to, she sued and was able to provide information that the son's record was, let's see, it was from a prior accident. It was a shoplifting infraction below the level of a misdemeanor even. So while they were treating it as a disqualifying misdemeanor, it was actually an infraction for shoplifting. And given his ensuing disabilities from an accident, there was no risk, or very low risk, that he was going to be committing any criminal activities. And so the court denied the screening company's motion to dismiss the case. So again, an individualized review might have saved them some grief there, but that case is noteworthy because screening companies are covered as well. So then I just want to move into this model policy that came out in August 2019 as a result of a settlement agreement between a housing provider and some, I believe this was a fair housing agency brought this case. I don't remember if there were individual complainants, but the attorneys on either side are really well-known, prominent fair housing attorneys, both for the defense and for the plaintiffs. And so the fact that they came together and that their clients agreed upon this model screening policy as a way to comply with the Fair Housing Act, I think is definitely good guidance as a best model policy for housing providers to follow to try and not violate the Fair Housing Act. And I think this can show those of us who are advocates for tenants and housing consumers what an ideal compliant policy would look like. So this again had to do with a blanket policy for felonies, no felonies allowed, no matter how long ago it occurred, no looking at the individual circumstances of how old the person was, how much time had elapsed, rehabilitation efforts since, anything like that. And statistics were proffered that a Black resident in Chesterfield County was 3 times more likely than a white resident to have a felony or misdemeanor conviction. So again, that goes to the step 2 of the disparate impact analysis. And so as a result of this filing, the parties entered into a settlement agreement that included a model policy that the housing provider is going to employ. And it has 3 steps to its process. So another 3-step process here. So the first one is the housing provider is going to do the income and credit screening first. Like I mentioned, don't even, it saves time and effort often to not even get into the criminal screening and mitigation discussion if somebody doesn't even meet some of the other qualification requirements. So number 1, income and credit screening. Number 2, a limited criminal background screening. So not a blanket policy, but looking at specific types of convictions and not arrests and a certain period of look back time. And then 3rd, an individual assessment if somebody doesn't pass the limited criminal background screening. So these are the 3 steps here. And nice thing about the settlement agreement is that it came as attachments with the sample policy as well as some sample form letters. And so I think it's easily adoptable and modifiable for other housing providers to utilize as a best practice. Of course, every state's penal code is different. There are going to be different crimes and levels of crime. And so definitely a housing provider would want to consult with an attorney in tailoring it to their needs. But I think this is a good step in the right direction of what a compliant policy would look like. So number 1 is the step 1, income and credit screening. And if somebody passes that, there's a form for a conditional offer. So they get a letter, conditional offer saying you've been approved, conditioned on passing this limited criminal background screening. So that's the 2nd step. So criminal background screening, but it's going to be limited. We're only going to look at people who are 18 and older, and we're only going to go back 5 years. So it had a 5-year look back period, and it is only going to consider felony criminal convictions. So not misdemeanors and not arrests, felony convictions within 5 years. And specifically, the policy states it's not going to consider arrests or expunged convictions, vacated convictions, sealed juvenile records, things like that. It's not going to treat people differently based on whether they're on probation or parole. So then the policy, and this is where a housing provider would want to tailor it to their own jurisdiction specifically, but for this state, felony property offenses were included as part of the limited look back at 5 years. So felony property offenses, including theft, burglary, vandalism, and arson. And then major drug offenses, drug trafficking, sale, smuggling, manufacture, distribution, and this was all 1st and 2nd degree controlled substance offenses, but it was not going to include simple possession of a controlled substance and past conduct that's since been decriminalized, as many states are moving to allow use of marijuana in certain quantities. Also included in the limited screening is felony fraud offenses, identity theft and counterfeiting, and so on. Major violent offenses, assault, battery, homicide, felony sex offenses, rape, registering as a sexual offender, taking indecent liberties with a minor, pandering, sex trafficking, sexual battery. It does not include, however, so-called victimless crimes such as prostitution or solicitation. So that would not be reviewed. Step 2, let's see here. They just reiterate that they chose these things because these are the types of crimes that convictions that may have an impact on the safety of people and protection of property. So they're spelling out that this is the necessary legitimate interests that they are trying to address. And then step 3 is the individual assessment. So even once they have given somebody a conditional offer based on their first review of other requirements and then gone through the limited criminal history screening, if somebody so-called flunks the criminal history screening, still doesn't pass something, they are sent a letter notifying them of that and given the opportunity to provide mitigating evidence or information within 14 days. So they're able to provide information that could be letters of support from the community, from parole officers, from AA meeting sponsors. It could be any kind of thing that is supporting that they are no longer at risk, or it could be records showing that it was a case of mistaken identity. Whatever it is, they should be given this opportunity to provide additional information. And then, based on the information received from the applicant, if any, the housing provider makes their final decision and considers, again, the age of the applicant, the facts of the circumstances, how long ago it was, what the specific type of crime was, and so on. And then they also consider things like, was the conviction the result of being a survivor of domestic violence? Was there mental illness at play? That can transgress into reasonable accommodations, which is not the topic of our webinar today, but somebody with a disability may have need for a reasonable accommodation to overlook some kind of a criminal mar on their record if it was the result of a disability, an undiagnosed disability, for example, disorderly conduct or something, and now they're receiving treatment and diagnosis and medication and no longer disturbing the peace, whatever. So you can get into reasonable accommodations issues as well there. So that kind of information may be proffered through the mitigation process. And then the housing provider makes a decision. If they still deny the person, then they need to send an adverse action letter. That would be true of any denial. Also in Washington State, under federal and state law, a denial of a housing opportunity is a adverse action, and a letter needs to be sent to the applicant with specific information about the denial. So that concludes where we're at with criminal history screening and Fair Housing Act. So to sum up here, HUD has this guidance from 2016. It's still in effect. It has not been rescinded. It follows the 3-step analysis used by courts and still being used by courts in cases that are being filed around the country. Some of the takeaways are that housing providers should not disqualify people because of arrests. They should not disqualify people because of any kind of criminal history, just having a blanket ban, like all misdemeanors, all convictions, all felony convictions. Those kinds of things are too broad. They have to have a legitimate reason for having their policy. And even if they do, they need to use the least restrictive way of addressing that, the least discriminatory way of addressing their legitimate interest. And HUD provides the roadmap in this memo by setting forth this process of an individualized assessment. And that model policy that I just walked through is, I think, probably a premier example of how to conduct that individualized assessment, how to formalize it. Again, it having been agreed to by parties represented by well-informed fair housing attorneys, nationally known attorneys on either side. So if they agree to it and it works for them, I think that that's a good best practice. Where does that leave those of us who work for or advocate on behalf of people with criminal histories who may be denied housing. Certainly if in your work you come across these blanket bans, now you'll know that those should not be the case, and I think there are still many. This is still something that housing providers and screening companies are trying to become informed about, and we're trying to spread the word. But if you see those types of bans, you can certainly inform a fair housing agency like ourselves, or there's another one, Fair Housing Center of Washington on the west side based in Tacoma. And we can both do education efforts to the housing provider. We can do investigations, testing to confirm discriminatory practices. If you're working with individuals who've specifically been denied, you can refer them again to our organizations. You can refer them to HUD. There's a HUD FHEO office in Seattle, or to the Washington State, the Washington State Human Rights Discrimination, and they can be assessed for filing a complaint. It's kind of interesting because, again, criminal history screening is not a protected class in and of itself. It's really correlated with disparities for people of color. And again, I still think you could make the argument for people with disabilities too in the criminal justice system, but it has to tie to a protected class. So with that said, I don't think that if a person who is white, not a person of color, is denied housing because of a criminal history that they have, I don't think that they would prevail probably in a fair housing complaint with HUD or the Human Rights Commission. However, they really get the benefit of these policies not being allowable under the Fair Housing Act because of their disparities on people of color. So again, while that person, a white person, couldn't file a complaint probably and prevail, certainly notifying agencies like ourselves of those policies, we can provide some education so that housing providers don't do that. And definitely if you have people in protected classes who are being denied housing because of criminal history screening policies, that's something that we can assess in trying to advocate for them as well. So I would say if you're encountering these policies or working with people who have encountered them, definitely get in touch with a fair housing agency in your region, or HUD or the Washington State Human Rights Commission. So, and some local jurisdictions like Seattle are enacting their own policies as well. And it may be in the future that the state of Washington does something more to protect people with criminal histories to be able to access housing, given the dire need of people to get into housing and the detriment of homelessness. So I'm open to any questions at this point. And one thing that we didn't do, I don't think, was the poll, unless you went ahead and did it, Amanda, to see what organizations and type of entities people are working in. But that would be interesting to know. Or also whether or not people are seeing clients or patients who are being barred from housing because of criminal history, how prevalent that is. I think we had a couple poll questions like that. Looks like there's one in progress now. Oh, okay. Have you heard from clients or patients about denials? And yeah, not surprisingly, about 75% of the people are saying, yeah, 14% no, 10% maybe. So yeah, it is a big issue that we've been hearing about for years, even before HUD came out with this guidance in 2016. So with that, are there any, looks like we might have time for a couple of questions, and then otherwise I'm also willing to follow up with written answers.
Hi, Marley. Thank you so much. Everybody is so excited about this webinar. This is great. We have, pardon me, clearing my throat. I have some wonderful allergies going on right now. It's that time of year. So we do have a couple of questions. So we're going to go ahead and try and, I'm going to go ahead and try and see if we can get questions from people who haven't left so that we can do immediate answers. So let's see if we can. Natalia wants to know a couple of things. First of all, why are screening companies allowed to report arrests? And she also wants to know, will registered sex offenders be reviewed? Well, excuse me, you did review registered sex offenders. There was a question about young people. There it is. Sometimes landlords ask to screen criminals for criminal records for occupants 13 or 14 and older. Is there anything that makes this practice unacceptable?
Okay, thanks, Amanda. So several questions there. Why are screening companies allowed to report arrests? I believe because it is, it's public record, and so they're able to access it. And there is some disconnect right now where we have this guidance from HUD, but it's not clearly spelled out in a statute, either by the state or by the federal government, that says you cannot do this. So anything that's out there is public record unless it's specifically prohibited. And until our laws tell them they can't, they can access and report it. Now, should the housing provider act on it? Definitely not. But yeah, who's not to say that they won't come up with another reason if they're aware of it? So yeah, that is problematic. There's a lot of disconnects between various different laws and no laws regarding this, and public information that's available. Yeah, I mentioned the sex offender that was in the model policy that was included, a 5-year look back period. And again, felony, there's various degrees and types of sex offenses, from indecent exposure on up. And so, yeah, that could be part of the mitigation discussion as well. And then young people, that is certainly something that we hear about. I'm not aware of anything that prohibits that, looking at somebody that young, but that arguably could have a disparate impact on families with children if you have more people in your household that you have to pay for to, have increased screening fees. So again, I think that's one of those things that's a little bit undecided, and I have not seen personally any guidance one way or another on that. So I think it's allowed, but again, a best practice would be, 18 and older.
Right. That makes sense to me too. Thank you. Another question that we have, an easy question I'm going to throw at you so that it doesn't take too long to answer, is do people have to be on disability income in order to qualify under the disability protected class?
No, yeah, that is an easy one. Thanks. So many of these are like, it depends. That's a gray area, and that it's this legalese
Right.
kind of. Yeah. Yeah, no, that's an easy one. To meet the definition of disability under the Fair Housing Act, it's a physical or mental impairment that substantially limits one or more major life activities: walking, breathing, lifting, working, those kinds of things. And so it's really an observational thing that doesn't even need to be diagnosed by a doctor. If you can observe somebody in bed every day, not able to, get out of bed and care for themselves or walk to the bathroom, you could be their third party verifier that they have a disability for the Fair Housing Act. Although, as a matter of bias, the closer the person is to you in relationship, the less credibility they're going to have. But no, you don't need to be. It's harder to meet the definition to get on SSI, SSDI than it is to just meet that definition for the Fair Housing Act.
That makes perfect sense. Also, another question would be, if a landlord charges double the deposit when they find out the tenant is being helped with an agency for move-in costs, would that be considered disparity or discrimination?
Oh, okay. Well, they're both discrimination. Disparate impact and disparate treatment are kind of the two different theories, but that would be different treatment. If you're allowing people who are not helped by agencies to move in at one price or one fee, and charging a different deposit or fee for somebody else because they're being helped by an agency, that's not going to be covered under the Federal Fair Housing Act, most likely, unless it's disability specific assistance or veteran specific assistance. Could be protected under our state law against discrimination. But our Washington State Landlord Tenant Act now does protect source of income. And so if somebody is receiving some subsidies or deposits from an agency, that could arguably be a claim under the Residential Landlord Tenant Act, and Northwest Justice Project takes some of those cases if people income qualify. So, but that sounds like intentional discrimination to me.
Yeah. Thank you, Marley. Would you, let's see here. Yes, Natalia, we're definitely going to send out the Q&A answers and questions for sure. So if you can still hear me over the sound of my dog running across the kitchen floor. Yeah, no problem. So Leanne Fogarty wants to know, and I apologize, Leanne, if I mispronounced your last name. That seems to be my lot in life. Also, just to clarify, she says, blanket policies are not allowed in Washington state. Is there a reference number to that in the law?
Okay. So blanket policies are not allowed really under the nation in the United States or Washington state because of disparities on protected classes, if your statistics in your community show that. But the citation really is going to be the Fair Housing Act or this HUD guidance. If you're trying to educate somebody about this matter, probably showing them the HUD guidance is going to be the best thing, wherein it cites to the Fair Housing Act and makes this, big long case that we've been going through today about the 3 steps and why a blanket policy can have a disparate impact. So unfortunately, there's not a Washington RCW that I could refer you to. And that's where, again, some policy clarification might be helpful from our legislature, both for tenants and for housing providers to know what they can and can't do. But right now it would be constructing a disparate impact argument under the Federal Fair Housing Act or the Washington Law Against Discrimination, but you're not going to find a specific provision in either of those laws saying that this is prohibited. I think the clearest thing is probably going to be looking at that HUD guidance and providing that and showing how that does become unlawful under the Fair Housing Act.
That makes perfect sense to me. You're welcome, Leanne. And how about denying clients due to income criteria, even though the prospective applicant is receiving assistance?
Okay, again, that sounds like source of income discrimination. And so you want to probably think about if it's a low income person, applicant, think about referring them to an agency like Northwest Justice Project, because that'll be under our Residential Landlord Tenant Acts as opposed to the Fair Housing Act. But if the issue is the type of income or that they're being assisted by an agency or organization and denied because of that, those definitely sound like source of income potential discrimination issues. So I would refer to a legal aid organization for some assistance.
Thank you. And Myra has a question. She says, hello, I have a question just to clarify. Can I request for an individualized assessment after a potential tenant was denied for a unit due to criminal history?
I would most definitely do that. Yes, I would most definitely do that. And again, use the ammunition of the HUD guidance as something that you can share to educate the housing provider and say, while this person was denied, under the Fair Housing Act, they would like to proffer the following types of mitigation evidence and ask for a reconsideration. So yeah, I think that's a great strategy for an advocate.
Okay, so there's another one in here. It says, I worked with a client who was rejected solely because they had a petty theft from shoplifting 4 years prior. Would that go against fair housing?
I think it would, again, for the individual, if they are not themselves in a protected class, a person of color or a person with a disability, or in a group that you could make out the case that they are overrepresented compared to their general population, they may not be able to file a complaint themselves, but if there is a policy that says no misdemeanors or infractions or something like that, which this petty theft would qualify under, that policy in and of itself might not be illegal against that person, but is going to have a disparate impact purportedly on other protected classes. And so I think it could be challenged. So some of it will depend on the demographics of that specific client. But again, using the HUD guidance, I would use that and say, it looks like your policy overall. So while you may not be able to file a complaint with HUD for this specific person, if they are not a person of color or a person with a disability, you could still advocate for them, I think, against that policy and say, yeah, this is a very minor thing, doesn't have anything to do, try and make the case that it doesn't have anything to do with what they would be doing now in their housing, safety of people, offer mitigation. So yeah, you can definitely ask, depending on the specific demographics of the person and the region. You know, there may be a fair housing case that you construct, but the policy itself, I think, is open to some challenge or education for the housing provider.
Okay, and it looks like there's one more, and I'm going to give you this last question, Marley, and then I'm going to let you have your day and everybody else.
Okay.
So Natalia has one more question, and she says, is there any studies on income requirements, 3 times the rent or a set amount of money, and disparate impact as POC are overrepresented in low income / poverty?
Wonderful question. I like that. All these theories you can really extrapolate to other areas. Yeah, definitely. I think that you can, and there have been cases made about income, public assistance, sources of income, and being unable to meet 3 times the rent requirement, and that having disparate impacts on either people of color, persons of color, or people with disabilities. I know there was a case in the Bronx, it was a number of years ago, but there was a case that was brought against a housing provider that did not want to accept, I don't remember if it was Section 8, it might have even just been some other type of public assistance subsidy. And in that particular community, which was highly African American, and looking specifically at who was receiving that type of subsidy, it was overwhelmingly African American. They made the case that that was a disparate impact. So most definitely, and the same I think can be done with people with disabilities who aren't going to be able to meet a 3 times the rent requirement if they're on a fixed disability income like SSI or something. Under our state source of income law, under the Residential Landlord Tenant Act, you only the housing provider should only be considering that person's portion of the payment that they are responsible for if they're applying a 3 times the rent. And a person with a disability can also ask for a reasonable accommodation to waive a 3 times the rent if they have fixed disability income. So there's a variety of ways that you can address that. So yes, if you are dealing with somebody in a protected class, and statistically you can show that a policy is having a disparate impact on that protected class, you potentially have a Fair Housing Act issue and or a state source of income claim.
Marley, I want to say thank you from DBHR in Washington State for all of your amazing information and how helpful you've been in answering questions today. And we're all incredibly grateful for you taking the time for us today and explaining this to us and helping everybody out with their housing situations with their participants. And we also want to remind everybody that April 23rd, we have another monthly housing topical webinar coming up for Secure Your Oxygen Mask, Vicarious Trauma, and Self-Care. And then also in May, Marley will be back to talk to us about service animals versus therapy pets and what that looks like for our participants and for us as service providers. So thank you all very much for taking the time to come and listen to us. Thank you very much for staying safe and healthy. And Marley, thank you so much for all of your hard work and dedication to Washington State.
Well, thank you likewise, Amanda, for all that you do, and all the folks on the call here for taking the time today. I hope you all stay well, and thank you for having me.
All right. Well, thank you. And everybody, I'm going to go ahead and end this now, and you have a good day. We'll get everything sent out to you ASAP and taken care of. Thanks, guys. And Marley, I'll get those questions out to you as soon as I possibly can.
Sounds good. Thank you.
Okay, guys. Thank you. Bye-bye.